Hi, and welcome to Lady Rosa Legal Briefs. I'm starting a little bit late because life happened, as it does. Not sure if I'm going to have anyone join me tonight. Probably not, because I haven't told anyone. I've got a group of people I'm going to be telling about this channel, and I was going to contact them this morning, and it's just been one of those days. Hoping to have fewer one of those days, but that's just how it is at the moment. So I've done a bit of a PowerPoint presentation, and because of the way I've set it up, I'm actually going to get rid of my face shortly and just talk you through what I want to say. Today I want to start talking about how you actually go about instructing a lawyer. Now, when I was working as a lawyer, one of the things I noticed is that people have a really hard time at their first meeting with the lawyer because it's not something you do every day. They don't know how to tell a story. And I mean, I had this one couple come in to see me, and they're telling me all this story and all of these things that happened, and oh my God, and it's like, there's going to be a question soon. And then with 15 minutes to go, they said, but that's not why we came to see you. And it's like, but it was so interesting. It sounded like a real legal problem. And yeah, that wasn't actually what they wanted to ask about. So you've got to be really aware that, especially if your first interview is one of the free or really low fee, your lawyer needs as much information as you can possibly give them in a way that they can sort of understand. And lawyers aren't supposed to be sitting there thinking about how they're going to solve your problem while you're telling them your story. They should really be, what I did, and I may or may not have been right in doing it, but I would listen to the story first and then get people to repeat stuff so that I would write the notes then. Because in the first telling, like 10 or 15 minutes, you tell me your story, I sort of get an idea of what we're looking at, and then I know the kind of questions to ask. So then we go back to the beginning and start again. And that was just my way of doing it. And every lawyer does it differently. But, it's really hard for some lawyers because they want to jump in and solve your problem. The more they know to, give you, the better it's going to be. Or they sort of think, it's this kind of a matter. I can deal with that, because lawyers aren't supposed to take on clients with matters that they can't deal with. So there's a judgment being made to see if you've got what it takes to do it. Generally, you can. If you want to change from one area of law to another that you haven't worked in before, you can do extra training on that before you actually take on clients, and then you're back to using your legal skills to build on the new knowledge in the new area of law. So it's not really an issue. A lawyer can learn how to deal with your issue as long as they know what it is. So you need to be able to instruct them. If you're unable to instruct them, you're kind of hampering the lawyer. So if you've been playing along and you've heard anything about me, I was a client well before I was a lawyer, and I didn't know how to instruct a lawyer. I sort of knew the basics of what I needed to tell them, but I was hampered by the fact that I'd watched a few too many legal shows where, the lawyers draw out the story and, they've got this magic bag of tricks and they pull it all out and, they save the client and they're dedicated to the client and, there's a wrong been done, so we're going to jump in there and that doesn't help. So I had the good old rose-coloured glasses, and my lawyer and I, we weren't a good match in that I knew what I wanted to do. I gave my lawyer instructions. My lawyer didn't quite follow my instructions, but I didn't know that there was this Legal Profession Act that, and there were conduct rules and that, I had power. So I kind of didn't know what I was doing. I didn't know enough about... I knew my story and I could tell my story. And my story I could tell really quickly and shortly. But there was a disconnect between how I was telling my story and what my lawyer was hearing, I think. I don't know. I'm just making this bit up because I wasn't in his head. I don't know what he was thinking. I know that he was recommended to me by a barrister I knew. And the barrister was going to be, doing it. So I thought the barrister had more of an input. It's not how the system works. It's really weird. I had all of these ideas, and now that I've become a lawyer, and even though I'm not working now, you kind of figure out how things work and how they don't work. So I've put together a bit of a slideshow just to sort of help me to remember how I want to go with this and what I really want to tell you. So I'm going to just take my mug away from here and get on with the slideshow. So, how to instruct a lawyer. So it really helps to know the basics. You really have to know what you want, where you want it, and how to do it, pretty much. The basics are, that something needs to happen. You need to know how to instruct your lawyer. So let's see if we do this. So I have to remember to tell you that nothing in this video is legal advice. And if you need legal advice, see a lawyer, even if you only get an initial advice. If you think that the lawyer hasn't quite understood your story, either keep talking to them or get a second opinion. If two lawyers tell you, look, you haven't got a thing, then go with that, because you can throw a lot of money at a lost cause. That said, it's a murky area, but I am not giving you legal advice because I can't give you any legal advice at all. So you start off with, you really have to know your story. You've got to know the facts. Your lawyer knows the law, but he can't do much with the law unless he's got the facts to sort of see how the factual matrix fits in, and is there a legal issue arising. So, and all the facts matter. You might think that it's something irrelevant, or, you make a judgment call that it was something that, you sent an email, you said something in the email and you're sort of there, I won't mention it. I can tell you that whatever's in the email, the other side's going to be reading it and they'll do something with it. So you've got to know your story. You've got to know it inside and out, because you want to be able to tell your lawyer. And you know your story, but you've got to know the facts of your story, and you've got to be able to put it in terms that are easy for your lawyer to understand, remembering that a lot of free and low cost legal advice interviews are about half an hour to 3/4 of an hour. So you've got to be able to get the story across pretty well to get a reasonable idea of what the go is. And sometimes you open up your mouth and say, this has happened, and the lawyer says, you've got a case. It's easy. But it's not always straightforward. And especially if you're in something with banking where, you signed a contract, you've defaulted on the contract, and the bank is now asking you to pay all of the loan back, but you don't have the money to do it. And that's straight contract law. So, you would think that you're out just, hand over the keys and be done with it. But the facts might actually show that that's not quite what happened. There were a lot of things happening. You were influenced in a way that you shouldn't have been. There were nefarious things happening, dodgy things. Unless you know the facts, as in, if you've got a timeline, it's all good. So one of the things that you don't want to do with all of these facts is don't hide things that you think might be bad for you. Now, I never did, because I had a barrister once tell me that I would be shocking on the witness stand because I'm too honest. And it's like, well, you could have trained me I could have had training to not keep going and just answer yes or no. But, apparently being honest is a bad thing. And I still have a hard time reconciling that. But, she knows what she's doing, so I'm guessing she was probably right. But one of the things you've got to remember if you're instructing a lawyer, even if you don't have that lawyer afterwards, by talking to them about your matter, client confidentiality does kick in because, you've gone there for legal advice. Sometimes you might think that it's really, really bad and you don't want to say anything until you've signed on the dotted line to, you've signed the retainer agreement, and that's fine as long as you don't keep hiding it. One guy who came to see me for just some general, he wanted me to do something for him, as in what I'm now doing, where I go through people's documents and help them put it together to instruct a lawyer. We were just talking generally while we were doing this stuff, and he happened to say something, and I'm there, oh, and what did your lawyer say about that? And he says, I didn't tell the lawyer that. I'm there, but that bit of knowledge actually made your case. That proved the point. And he said, what do you mean? So I sort of went through it, and I'm sort of there, that could have, you'll have to put it into this one, because even though you think it's bad, it actually isn't. It's quite good, actually, that, this definitely proves your point. And, I'm not sure why he thought that. I guess he was embarrassed. It's embarrassment stops us doing a lot of things that we should do. I know there were a couple of things that I really didn't want to come clean with the lawyer about because it was so embarrassing. But I told him, and he didn't do anything with it. Had it gone to trial, it would have come up, and I would have had to have taken a stand, and and everybody would have said, "Oh, you stupid woman." But that wasn't the issue. The issue was something else, so it wouldn't have scuppered our case. And I can say that now, having spoken to other lawyers about it. And, what's your take on this particular bit? And I'm so embarrassed about it, but it's a nothing burger. Doesn't matter. Our case is settled now. But, I told the lawyer. So honesty is always the best policy when you're instructing a lawyer in civil law. Do not, if you're listening here and you've got a criminal matter, in criminal, silence is golden. If you tell your lawyer too much, then they might become a witness against you, which I would have thought that would be impossible, but it is quite possible. And you're also putting the lawyer into a position that they really can't maintain. A lawyer can't put in an innocent plea if you've admitted to them that you're guilty. It's, you can't lie about certain things. You can't put forward theories when it's all pretty complicated. So be totally honest in a civil matter and answer your lawyer's questions when asked. They'll ask you what they need to know. They'll ask what they need to know from you. I've never had the pleasure of dealing with someone who was hiding a lot of stuff. It was all pretty straightforward. So, but yeah, in civil, you can tell your lawyer all of the facts. If it involves an email, of course the email's going to surface. If, sometimes facts surface afterwards and the lawyer panics and, thinks, how am I going to deal with this? Whereas had they known from the outset, they could have mitigated it from the beginning. I remember my lawyer really freaking out because I hadn't told him that I'd worked for the bank, and that's because I'd forgotten. It was such a forgettable experience because I was only casual and didn't really do a lot of hours with them, and it had been 10 years before and didn't last very long, and I never quit and I wasn't sacked. So technically I was still on the books as a bank employee, which kind of really amazed me. But there you go. It freaked him out. It wasn't really relevant, but the bank's lawyer tried to make a big deal out of it, and I didn't hide it. It was just something I hadn't thought of. It was really weird. I figured that it wasn't relevant, and according to the judge, it wasn't relevant. So client confidentiality is important, so there you go. Now, one of the things that I've noticed in talking to a lot of people over time is that most people don't realise that it's the client who instructs the lawyer and the lawyer gives you advice. But as the client, you're in the driver's seat. It's your call. The lawyer can give you options. So, the lawyer might say, look, you've got a really great case here, but the problem is it's very complicated. And while we can, one of the options might be you write to the other side, you say what the problem is, that, you've got a really good case, but you're prepared to settle it out of court for X amount of dollars to make it go away. And depending on who the other party is, they might say, I can't be bothered going through this. And if I lose, it's going to be much, much worse. And if I win, I'm only going to get some of my court costs back. So, I'll settle it. And then, the lawyer might say, and if they don't go for that, what you're looking at is, and then he'll give you some of the other options you might have. Or she, I'm a female lawyer, it goes without saying that, it might be a woman lawyer you're seeing. But, you've got to remember that the lawyer can't tell you what to do. In wills and estates, a lot of the times executors think that they must follow the lawyer's advice to the letter. They can't instruct the lawyer to just settle some things, everything's got to be litigated. Well, no. The client is in the driver's seat. So if a lawyer is telling you, oh no, you can't, if you're an executor and your lawyer is saying, no, you can't settle this, you as the executor must keep fighting, then, might be time to get a second opinion on that one, because it's that's not quite the way it works. Oh, come on. There we are. So Western Australia is adopting the Uniform Law Australian Solicitors Conduct Rules. We'll be doing that June, July, I think. Haven't actually found a starting date. I know that it's coming up. We've got the legislation in place. But I've got both. When I did my training, I did it through Charles Darwin University in the Northern Territory. And the Northern Territory is under the Uniform Law, so I actually did both when I was studying. And as a lawyer in Western Australia, I come under the Legal Profession Conduct Rules 2010. Now, in Part 3, it's relations with clients. And Clause 7 is all about client instructions. And I'm not sure how many people are aware of the actual client instructions that exist. Because the very first one is that a practitioner must follow a client's lawful, proper and competent instructions. So after the lawyer's given you your advice and you've made a decision having weighed up all of the pros and cons and the ins and outs, and you've really thought about it, and you instruct your lawyer to do something, your lawyer has to follow your instructions. Your lawyer can't say, no, I'm not doing that. You can't say, well, if that's what you want to do, I quit. The lawyer-client relationship has irreparably broken down and I can't do this. It's in the legal profession rules. It's no. If they are competent instructions, the lawyer's got to follow it. You can give a disclaimer and say, look, it's going to cost you a mozzie, you're going to lose. I don't think it's the way to go. Now, the legal professional has to treat a client fairly and in good faith. And the giving due regard to the client's position of dependence. And that's where the lawyer-client relationship is very, very difficult, because lawyers are seen as the holders of all knowledge. They know the procedures, they know the law, they know what happens next, they've seen it before, they've dealt with this before, they know the fallout, they know what happens. It's this whole thing where a lot of people actually just want to hand over the whole kit and caboodle to the lawyer and say, you sort it. That's a problem. Because when you have that level of dependence on the lawyer, if the lawyer isn't doing the right thing, you can lose everything. And you don't even know it's happening because you're dependent on your lawyer for the good legal advice. If he's not giving it, if she's not giving it, or if they're not giving it, then, you're the one who pays the ultimate price. It's not the lawyer, it's you. Now, clients are entitled to trust their lawyer. Most lawyers are really good. They're decent people. They work hard for their clients. There's not that many dodgy lawyers out there, but there are dodgy lawyers out there. Anybody who says, oh no, the legal profession is all that, no, it's not. But some of them make mistakes, and some of them, a very, very small amount, would actually set out to do all of this stuff. So, But, I like the last one. So I will go through them, but my favourite one is the very last one. Now, C is, the lawyer must be completely frank and open with a client. And that includes saying, you know what, mate, you've got a slim chance of winning. It's not a risk worth taking. Just, the reward at the end, if you win, is not enough to warrant going ahead, because if you lose everything. If your fees for a matter come to $300,000, well, that's your house if you've got nothing else. So, it's a problem, and you've got to pay your own fees, and if you lose, you've got to pay the other side's fees. And if you win, you don't get all of your fees back. You only get back some of it. So, lawyers have to be frank with where the problems lie, how much it's going to cost. Cost is a really big thing. And, anyway, D is, got to act in the best interests of a client in any matter where the practitioner acts for the client. So there is such a thing as lawyer-client conflict. So sometimes you might not know that your lawyer has an interest in something that you're interested in. It's hard to describe without actually going to a case where, the lawyer ended up looking after their own interests to the detriment of the client. But I have read some cases, so it does happen. And yeah, it can be a problem. They have to perform the work required on behalf of the client diligently, and they can't accept an engagement which is beyond the practitioner's competence. So this is what I was saying earlier. To be competent to practice something, you might just have to learn that area of law, and there's ways of doing it. And, everybody learns on the job. It's a lot of work to be a lawyer. So if you want to change into a different area of law, that requires a bit of dedication and, getting on top of what the law is. Now, G is not accept an engagement unless the practitioner is in a position to carry out and complete the engagement diligently. Now, that would be like, I know that everybody likes a busy lawyer because, they've got a lot of things on the go. They're obviously popular. If a lawyer's busy, they're obviously good because everybody wants to have them. The downside to that is if a lawyer has too much on, they might not be able to do all of the work, might always be late filing documents, things might slip through the cracks because they're too busy. And so there's a rule against it. Don't take on a client if you can't actually look after the client. Because if you've got too many clients, and, to really to meet your billing targets, you probably have to have a minimum of 35 active clients where you have to work on the files. But if those files all come up with big things at the same time, then you're stretched pretty thin. So, are things going to slip through the cracks? Well, the legal profession rules say, if you're too busy, then you might be breaking the rules. But my favourite one is Rule 7H, and that is not to perform work in such a manner as to increase the proper costs to a client. Now, my pet peeve is billable hours. I loathe them. I think it's a very bad system because clients can't, it's really hard for clients to control costs. And, sometimes it looks really reasonable on paper that, the lawyer did this and the lawyer did this, and, it's work that had to be done. But I can tell you, when I looked through our invoice, we were triple charged on, the one case that my lawyer or some poor pleb in the back office researched. They only found one case, and I can think of about 7 that were relevant at the time, off the top of my head, that should have been used. But never mind. That I found them later when I learned how to do legal research. But lawyers can rack up charges really quick. And a lot of it is legitimate. I mean, when you have to read documents, you know, if you're going to be reading thousands of documents and putting your knowledge on it rather than getting somebody else to read it because they don't have the experience you've got to be paid for that. And a lot of lawyers know how to quickly read, but they still read the document 2 or 3 times because they have to. Because on a first reading, you're sort of highlighting things, and on the second reading, you're sort of getting more into the nitty-gritty because you've put it together with other documents that you may not have read the first time. And by the time you're getting to the spiky end of this, there's a few documents that you will be reading again, and you will be highlighting where all of the issues are. And this isn't because you didn't understand it the first time or the second time, but because you're now putting it into context in the overall thing. Like, you know, in a bank case, it might be you need to know how were the employees paid. You know, the person who wrote the loan, did they get, at the time, were they paid a bonus on how many loans they wrote? Was there a target? And if there was, did that make them more likely to give a loan that they shouldn't have done? And what other documents exist around that topic? And then, well, what was the employee actually paid? Did the employee really get a bonus, or didn't they? If they didn't get the bonus, you know, some cases, if a $1 million loan gets them the bonus, maybe that's what made the loan good, and maybe that's why the employee did what they did. But, you know, the lawyer's got to really read the documents and put them together. And, yeah, you can get a junior to do it, and that's fine. And the junior will read it and do a synopsis of every document and what's in it, what's relevant, what might be relevant, they don't know. They're thinking it could well be, so that's what they do. And then the senior lawyer still has to do it. The senior lawyer still has to do the work. I mean, how many lawyers are working for the law firm you're with? And, you know, who's doing the research? And it's all adding up. All of this adds up. And they're legitimate costs. But on some cases, you might have a lawyer who's over-servicing clients. I think there's a fair few cases where they have. I might do a bit of research on that. I'll take a note of that while you're not watching me write this down. Okay. And I might have a chat about them, either for a case note or something else this week. But, you know, I like the fact that there is a rule against lawyers overcharging. Legal costs are phenomenally high. I can see how it happens. But again, I hate billable hours. And I think on some cases, when you're dealing with similar matters all the time, there's a certain amount of work you don't have to do over and over and over. So you don't have to charge your client a mozza for it. The client isn't paying you for your time. As a client, you're not paying for the lawyer's time. What you're paying for is the knowledge and experience. And more so the knowledge. They know how everything fits together, and they know what doesn't help your case. You know, I have seen some documents come through where obviously the lawyer had just thrown all of the case law at it without reading the case and without knowing that they've cited the wrong case for the wrong point, and, you know, it just made no sense. It's like, why would you quote this? You're just throwing cases in there to make it look good. But that's just me being me, so probably that isn't what was going on. But because you're paying for the knowledge rather than the time, I think if a lawyer is well organised, and if say you're working in a small law firm where it's just you and there's a receptionist or whatever, and you don't have a lot of support staff, then you can set up your documents well enough so that as long as you limit the kind of cases you do, you're not doing endless research. You're keeping up with the latest case law, you're keeping up with the developments in other jurisdictions and the High Court. So you're kind of increasing your knowledge base as a normal part of, being a lawyer. So you don't have to charge your clients as much for certain things. So you know how much it costs you to produce documents. You know how much time it takes. And you know that on a certain matter, you might spend 30 hours. So you can take your time into consideration and, do up your costs from that, and then the client gets the costs. And as I say, I don't like billable hours. Lawyers find a balance really quickly once they go over to, the pay-as-you-go, essentially. Another good thing is that you don't end up having to have money in a trust account, and, you as the client would only pay for the work that you're getting done. So, when the reason lawyers don't like it, or one of the reasons why a lot of lawyers are resistant, is because they've got to do the work first and then you pay for it. But if you want a really good legal advice, and then it's not a complex matter, madam, so we're going to charge you $3,500 for the legal advice going into this, and then you pay the $3,500 when it's done, and you get your legal advice, and you say, what am I going to do with it? But if you're paying money into a retainer and they say it's going to cost you X amount of dollars to get to this point, and then whatever, sometimes that money runs out really quick and you don't actually get what you need. And I think that's where my gripe comes from. Having been given a quote and it kind of went way over, I'm a little bit attached to doing the right thing by people and keeping costs low. Oh God, I'm dribbling again. Yes. Now you need to be prepared for your first meeting, and everybody thinks that they're prepared because, they've sort of thought about it and they know that they've got a problem. But before you go in to see a lawyer, and I'm talking from personal experience as a really badly prepared client who was freaking out by the time I ended up getting a lawyer. Time was running out, in my opinion. The stresses on me, it was shocking. God, I hope you can't hear this chair. It's driving me nuts. But I'd asked what documents I needed to bring in. They weren't interested in documents. I brought some. I knew my story. I knew what I wanted to say, but I really couldn't back it up with enough stuff. And the lawyer took me on, so obviously I had a defence. But what I would suggest is you sit down and just do it on a piece of paper and write it out. You can sit there while you're watching the news or something else on the telly, if that's your thing, and just put together a rough chronology. Like, if it's a banking matter, what was the first time that you approached the bank about the loan? Or what kind of conversations were you having with which bank employee? Were there any emails? Have you got a list of phone calls? Did you keep a diary? Just go through that, and when did you put in the loan application? What documents did you sign? Have you got a copy of any of the original documents? Go through what you've got, put it all into some sort of a chronological pile. At this stage, you're not going to do very much at all. You're just going to write out what happened when. Any snippets of conversation that you remember, like, were they positively gushing about your brilliant business plan like they did mine? Which, yeah, let's not go there. But, was the conversation a bit too encouraging? What have you got? What do you remember? Just a chronology. When did you sign the contract? Did you understand it? Did you read it? Did you get legal advice on it? Whatever you remember. And then, when was the loan drawn down? Did the money go into the account? I've heard of one case where the money didn't go into the account. So they've got a loan, but they haven't got the money. So how do you reconcile those two? Was there anything untoward? How soon after the loan did you find yourself in trouble? If your house settled in the July and you were starting to be pushed by February the next year and your financial circumstances hadn't changed, that might be an indication that maybe you shouldn't have gotten the loan. So how come the loan got across the line? And everybody says, well, you've signed the contract, so you've got to pay out on it. Well, yes, you do. A contract's a contract, it's a contract. Unless there was fraud, unless there was undue influence, unless. So these are the things where if you put your story into a bit of a chronological order, if you're being issued with default notices within a year of getting the loan and your financial situation hasn't changed, like you've still got the same job, you've got the same expenses, nothing has changed, then there was a problem with the loan. That's my humble opinion, because if you couldn't afford the loan, how come you were given a loan? At the moment, we still have the responsible lending laws, which means the bank can't just give anybody a loan. You can't give someone who can't afford it a loan. So, and then I know, usually I waffle, I do. I was reasonably good in my humble opinion, but it's a long time ago now. I think 12 years is a long time. I suspect I didn't do as great a job as I thought. I'm sure I didn't. I cried. Did I cry? I don't know. I might not have cried. Who knows? I was pretty stressed. I was really stressed. And I imagine that I did a lot of waffling. But, we'll look into it. So from your first meeting and getting we'll look into it, you should really be getting a bit more information to move on. So I think personally, I wasn't expecting an instant advice. It would have been really good to have put my mind at ease. But I realised with the scant information that I had that I could give to the lawyer that he couldn't really tell me how this was going to pan out. He wasn't positive. He was quite concerned, but he wanted to know more information. Now, sometimes, and I've had people come into me for legal advice, and they tell me what they want to do, and it's like, well, that's not actually a legal issue. For the issue you've got, you're better off doing XYZ. Don't waste your money on a lawyer, because you haven't got anything that you can take to a court in the end. If all else fails, you've got nothing to stand on. Lawyer can't write a cease and desist letter to your neighbour on this particular thing because there isn't actually a law against it. That kind of thing. So, it's there are things where, it's bad luck. Now, if there are legal issues, a lot of really experienced lawyers can go with their gut and say, yeah, we can do XYZ for you. But then that advice might have to change as soon as they get the documents anyway. So, as soon as they get more information, it changes the picture, especially the information from the other side. Now, a lot of the time, the other side's got things that kind of put a different slant on things. So, is it real or not? Who knows? But it means that you shouldn't expect instant advice, because you want good advice. You don't want any advice. You don't just want advice. You want good advice. And to do that, your lawyer probably will need more information, a lot more information. They'll have to talk to you for quite a while, I suspect. There'll be documents they'll need. Did this really happen? Is this really in the contract? Was this really a thing? Are we sure this could have happened this way? Or is there something that, it's amazing how many things come out in those documents. And of course, for a lawyer to give you really good advice, they probably want to think about things a bit, because even though you can say, oh yeah, this is unconscionable conduct because it's a guarantee case and it's right on point with Amadio, it might not be. Amadio, the Commercial Bank of Australia versus Amadio, two elderly Italian parents were done over by their son, essentially, with the help of the bank, and the bank was held responsible for their part in it because they didn't do something. I'll probably do a case note on it, because Amadio is still good law, so that might be interesting to do that as a case note. But once all of the information's there, there might be really good solutions that don't involve a trial. A really great lawyer will try to keep you out of court, because court costs, it's, a good barrister's $10,000 a day. If you've got a 10-day court case, just your barrister's costs are going to blow out. Some barristers are doing a spectacular job at a quarter of that cost, but not many. As in, not all of them will do a good job, but not many of them will keep costs really low. It's a day in court, because they can't sign up for anything else, so they essentially have to charge you for their day. It's a fee structure, so and of course your lawyer might give you not an instant advice, might give you an indication of how this might go. Then they'll get more information from you and, explore it a bit more. Then they'll look at all of the options that they might have. And, chances are they'll ask you, would you like us to put together a barrister brief to ask a barrister how you'd go? And although that is an extra step and it's going to cost you more money, you know how it saves you money? Because from the barrister, they'll give you a chance of success. They'll tell you some more alternatives. They'll tell you where the flaws are and where your strengths are. And I'd always recommend, right at the beginning, when your lawyer is first putting stuff together, get a barrister's advice, especially if you're the one who wants to do the suing, or, if you're being sued, or, you've had a default notice issued, there is enough time to brief counsel. So it's, this is why lawyers shouldn't be too busy to do the job. But, I'd be lying if I said lawyers are all in it for themselves. They're not. There are very good lawyers out there, and not only are they good in how quickly they get work done, but, they have a really good code of practice in themselves. They hold themselves to a very high standard. Of course, some don't, but most actually do. If they stay in the law, they're pretty good. And, of course, I would have to say, don't panic, because not everything has to be resolved, immediately. I think my biggest problem was panic, because I don't know how other people are situated, but with us, I used to go out to environmental meetings every Tuesday afternoon, and they would start at 5. And every Tuesday afternoon at 4, the bank manager would phone me. This is the toe cutter from Perth. He would phone me and say, "Oh, I don't know why you're fighting this. You'll be out by Friday." Every time. And this was right from the beginning, before they'd filed any documents, before anything had started in court. He said, "You'll be out by Friday. Don't bother." And it's the sense of panic that I felt even for weeks after we settled with the bank. So we lost summary judgment, we appealed, our appeal didn't get across the line, we sued the bank for damages, and the bank settled that out of court. I remember it was weeks afterwards before I stopped feeling that panic. The whole time that we were living in Perth, I wasn't functioning properly because of this sheer panic all the time. And once I was studying, once we got to Perth, I did my Bachelor of Arts, and I finished that once we moved to Mandurah. But, we'd been here for a bit before one morning I woke up and it was gone. And I tell you what, I wouldn't wish that on my worst enemy at all. It's a horrible thing. But in the law, you can, if you have to, the court doesn't like it, but you can ask for extensions if you need to, as long as you've, if you've been self-representing, you can ask for an extension to get the legal advice you need. Lawyers can get extensions if they have to, but usually they don't. If a lawyer's dealing with it, they'll be on top of it. And this thing that I went through, that was only for, instructing your lawyer the first time that you meet them. Because as your relationship with the lawyer develops, you need to be working as a team. Your lawyer, you have to really remember, and I will do a live on this one on costs. Just remember that if you're phoning your lawyer every 5 minutes, and if you're sending them chains of emails that you're making them read, a lot of lawyers won't charge you for every single phone call, but tell you what, a lot of them will, because every minute that they're talking to you about something that's irrelevant, that's time that they don't have to spend on either your matter or another client's matter. And even though you're paying for their knowledge and experience, when you waste their time, you will pay for it. And I know from personal experience that we think that everything that's happened to us that we need to tell a lawyer is super important. But when you've told the same story for 6-7 hours, it's not adding any value, and it's not really helpful. Sometimes you might get a little speck of something useful come out, but a better way to get that useful speck out would be to do a comprehensive chronology, and I will do the comprehensive chronology. I'll just write some more notes for myself. Ah, yes. And I think that's it. They're my notes. So look, you have to know how to instruct a lawyer. You've got to know that there are rules for the lawyers that they have to abide by. If you think your lawyer hasn't been following the rules, you can report them. In Western Australia, it's the Legal Profession Complaints Committee. Every state and territory in Australia has an equivalent. Other jurisdictions overseas would as well. But sometimes what lawyers do that upsets clients isn't anything that the Complaints Committee can handle, because it's not a complaint about their work ethic. It's just that they're not very good at people relationships, and they, some lawyers tend to be very off-putting and come across as being arrogant. It's just a personal thing. It's, we shouldn't read anything into it. I mean, some brilliant minds really can't connect with people, so the law is a service industry, but some lawyers are like some doctors with no bedside manners. But sometimes you get a really brilliant lawyer who's not very good at people skills, and other times the people skills are lacking because the lawyer has no confidence in their own abilities, and sometimes that comes through as being, they try to bluff their way through. It's phases that people go through. It's a human thing, not a lawyer thing. So you find that in all occupations. It's whether it's a profession or, whether it's just somebody down working at the Shire who's got a lot of power by their position. It's I tread a really hard path doing what I'm doing, because I know there were a lot of bad lawyers around, and I know there are lawyers being reported all the time. What happens with them is, I know that I have a duty to the court and to the profession. Even though I'm not practicing at the moment, I do have my practicing certificate and I am on the roll of practitioners. But, heart on my hand, I only know of 3 lawyers, and I don't know them by name, who have done something that might be considered dodgy. I don't know the facts, so I don't know. And as I say, I don't know the names. So is it a large number of lawyers? I don't know. There's large turnover in the law. There's lots of ex-lawyers around. Lots of lawyers quit because it's just untenable. You can't keep putting in those hours. So I know there are some clients who've stuck with a law firm who've had 5 or 6 different lawyers on their matter. It's really hard to build a relationship, and that when the lawyers keep changing. Now, when lawyers leave, they're supposed to do a proper handover. All client files have file notes on them that sort of update, what's happened, what stage are we at, what still needs to happen, game plan. Things are diarised. So when it happens, it's not always the end of the world that, there's another lawyer involved. It's really horrible when you don't develop a relationship with a new lawyer. Hard to sort of imagine what that's like. As I say, I know a few people who've had a lot of lawyers. I know of a criminal case where I think it looked bad to the jury because the barrister who'd been involved wasn't there suddenly, and to me it wouldn't have looked good, but what do I know? But the barrister didn't abandon the client. It wasn't like that. There was just a clash, and because the clash was a trial that was going to go for 10 days, the barrister obviously had to do the 10-day trial, and that happens. And it's hard for clients to sort of understand, with all of the rules and things, how sometimes you don't get what you think you've paid for. And, when you go to court, you get the law. I personally think you hardly ever get justice. And I think it's a bit rough. It's not good. So hopefully I will be able to be a bit more positive in some of this stuff that I do. I will be looking for cases where lawyers were over servicing and got in trouble. I will also look at doing a whole show where I'll show you how to do a comprehensive chronology, so that when you do that yourself, then you know what evidence you've got, what happened when, who, what, where, how, when, why. When you know all of that, if your lawyer makes a mistake in, say, writing down your affidavit, if they leave out information in there, well, I want it in there. Unless they can give you a really good reason not to put it in there, they probably should. And I will also do a video on keeping costs down. I will also tweak a lot of these videos so that if you end up being in that horrible position where you do need to self-represent, that I can sort of talk you through some of the stuff. So, like the procedural stuff, there's, it's just, what do you have to do when, and, how do you put an affidavit together. Now, there's lots of online resources for that, but sometimes it's easier to have someone explain it to you. So that's what I want to look at. That's how I'll do it. I hope that if you find this video, that you find it helpful. I've got my 3 screens, so I'll just check the other screen. I still can't sit properly. We'll be right. We'll get it sorted. Time will take care of that. Anyway, that's it. That's all I'm going to cover today. I hope it's helpful. Let me know in the comments what else you want to hear. If there's anything that you want more details on. I'm going to do some of these as the Patreon live streams. So at the moment, haven't kicked in my Patreon yet, so I will be doing that in the course of the week. My brain's finally functioning again. I love being off painkillers, but of course it's still painful, but yeah. Anyway, have a great night.